Hello, good afternoon, and welcome to the law. This is your legal light. It is your health law. And this afternoon, we are continuing from where we left off last week. And last week, if you followed us, we looked at the 50th anniversary celebration of the Judicial Service Staff Association, at which a number of speakers had a lot to say, including the Chief Justice, who identified the staff as being to blame for some of the issues that lead to delay in justice delivery or injustice in the process. So we're talking about administrative hurdles in justice delivery. How do you overcome them? A Deputy Attorney General says it actually boils down to the judges. If they decide to crack the whip, things will go fast and good. A former Attorney General, Aiko Otu, looks at all the angles, blames lawyers, judges, and the staff as well. This afternoon, we have the staff here in the studio and also a senior lawyer to help us understand what these issues are and how they can be overcome. I'm Samson, Lardy, Anyenini. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your health law. And my guest to the studio, Samuel Afote Otu, is National President of the Judicial Service Staff Association of Ghana. Thank you for joining us, Sami. And also here is Abdullah Yakubu, General Secretary of the Judicial Service Staff Association of Ghana. Thank you for coming, sir. Right. Patrick Amate Sobojo is founding partner, Sobojo and Partners. Thank you very much, Senior, for sacrificing an hour of your afternoon with us. Thank you very much. So get ready, and as we always do, you are a court user. You know some of the problems within the courts. Let us know what some of your frustrations are so we can help a holistic diagnosis and what should be done, particularly at a time when the Chief Justice is rolling out her vision, which is leading justice, making sure that things are done in the best way. Listen to the Chief Justice.
When a court staff who is totally unaware about how the law of contract works pretends and begins to prepare affidavits and court processes, and this is where the preachers will say, am I speaking to somebody? When you pretend and begin to prepare court processes for a court user who has already suffered from a damaged business transaction, we are adding to the messiness of disputes in the courts. And we are creating records that make justice delivery almost impossible. In the same way, a court staff who is totally unaware about how land law works and who pretends that they do, and so prepares an indenture for people entering into land transaction. Am I talking to somebody? That court staff is creating a nightmare of injustice. And indeed, it has been discovered that many indentures cannot be registered. And these have they reflect in the intractable disputes that we have in the courts. Even worse is the situation where court staff join criminal gangs to prepare fake divorce and other orders that have forged signatures on them. Recently, I heard some song, if you know, you know. Agbabola. You know, you know. The Nigerian man is here. You know what I'm talking about. So long as there are bloggers out there who need these certificates, they come into the court premises. And some of you have become traders in this thing. Let me assure you, I recently saw some videos shown by the CID after their investigations in the court premises and it's extremely disturbing. How is it possible? And let me also talk about the fake letters of administration orders that are used to wipe out the accounts of dead people, leaving their rightful heirs empty-handed and in pain. Please, let us stop these practices.
And that's Chief Justice Gertrude Araba Isaba Tokono, being as blunt as you would have it. Let me begin with Patrick Sobojo. She is simply relaying the frustrations of many court users, including lawyers, is she not?
Well, Samson, yes, she is. These are concerns that do exist. There's evidence that some of these practices have occurred. So to that extent, yes, I'll agree with the Honourable Chief Justice when she lists these issues.
Right. As a very senior practitioner yourself, share with us some of your own frustrations dealing with the system as far as it concerns the staff, because I know you would like to say beyond what frustration the staff may put you through.
I don't want to be putting the staff on the spot. I mean, we all work together in the same industry. As lawyers, we cultivate the law. As lawyers, we also profess to know what is just and equitable, and are constantly seeking. It's more like a perennial task to ensure that the administration of justice is delivered timeously and in the most cost-effective manner. I therefore don't believe that we can sort of hive off only JUSAG and then leave the blame for the hurdles we have in the administrative process of delivery of justice, but to include the bar as well, and in fact the very process by which our institutions work as being part of the whole system that need some form of relook or overhaul. I mean, as to stories, I'm sure I can list many from here.
I understand you. I understand you, and you are being very fair in looking at it from a holistic point of view.
Yes.
But let me get back. Are you excited? Are you happy with how, for example, bailiffs deal with service of your processes?
So certainly not. Certainly not. I mean, hitherto back in time when I started practicing, we had bailiffs. And now they've been termed the traditional bailiffs, and then we have contract.
That's right.
Contract bailiffs. Again, back then you could file a process today and have it served today. Today it's most unlikely because of the nature of process that is involved. It's filed and it has to be minuted to the contract bailiff. That is if it's for interlocutory matters. But for writs and orders and decisions, those are served by the traditional bailiff. So for instance, you have a situation where you need to serve a writ simultaneously with an application for injunction. So what happens is that the writ will go to the traditional bailiff, and then the application for injunction will go to the contract bailiff. But expediency demands that these two be served together at the same time. So of course you do have that overlap where, for instance, one process gets to the intended defendant before the other, and then it also dovetails into how you can get your proof of service together simultaneously.
Right.
So possibly maybe we could look at a way in which this a situation where we have contract and traditional bailiffs are sort of fused. So
you just mentioned proof of service.
Yes.
And that brings me to a point that I may want you to also tell me how you feel about the service in that area. When you file for a search, when you file for the record of proceedings or the court notes, when you make a request for them, will you say, averagely, you are satisfied?
It depends on situation to situation and court to court. Sometimes it comes pretty quickly, sometimes it doesn't. But in instances where, for instance, you need to serve because time is of the essence, you find that, you know, there are times when it's not adequate enough, and then your client suffers. And again, that goes back to the issue of justice delivery. So yes, I mean, to a certain extent, there are times where the issue of dealing with this proof of service thing is problematic.
Right. So kindly hold on for me. I'll return to you, and I'm sure that you will talk about the other aspect in the holistic approach that you want to take this. Now, Ms. Afoti, when you were listening to the CJ, how did you feel?
Well, I think
that some of your staff, you guys, actually connive with certain criminal, elements to engage in criminal conduct, doing things that you do not have the power to do and do not have the training and qualification to do.
Well, thank you. I think this issue, CJ is really doing well in tackling these matters. In fact, she is there to eradicate all forms of those habits in the system, and we are all proud of that. But I think, looking at the topic we are to discuss, this is just something small of it.
Okay.
Sometimes people get confused when we come to court, and they just refer to staff taking this here and there. But there are several issues that we have to deal with.
Such as?
Now, looking at the topic, we have something we call clearance from government. Sometimes you go to government for clearance to employ more staff, and it will take you several years. We are aware that we have commissioned, Anyenini started, I think, about 120 courts. And so far, 63 out of the 120 has been commissioned. Now, last year, Chief Justice program with the whole registrars and then heads of units in Kumasi shows that about 405 staff have exited. Have we talked about the replacement? Averagely, every court have to maybe have about 12 to 13 staff. It will surprise you that you go to some places in Volta region, we have 4 staff in the court. You go to Northern region, we have it there. Upper East. So looking at these trends, it's like it's not all that good. 2, when you look at, let's say, maybe limited or no subvention on capacity building, the law is changing every day. Every day we are getting new laws, and if technological change is also there. And Justice E.N.P. Soa, as he then was, the law is a living organism and capable of growth.
Right.
So as we are staff, we need to grow as well.
You're speaking like a lawyer.
So if government or maybe stakeholders are not ready to maybe give those subventions to train the staff, when the changes occur, how are we going to embrace it? Thirdly, we also have this lackadaisical attitude of members towards change. That's technology. Now the Chief Justice is doing everything possible to make sure the court go on digitization. It will surprise you that some judges or maybe some staff, maybe some judges will still write, and they write a whole lot of notebooks. Some registrars or some recorders will stay in office after 5 when we are supposed to close at 4. So if we are talking of effectiveness and efficiency, and people are not ready to learn or to accept the change, we'll face some of these things. I will commend the Chief Justice again when, in fact, we have some problem, that is mental health and then wellness. Recently, the Chief Justice, we cannot bear witness to that there are physicians who are psychologists, taking through the judges and the staff. It's taking them through that process.
To ensure your well-being.
Yes, to ensure our well-being. So I think that one is also going to help us as well.
Right.
Then finally, we'll talk about the infrastructure. Justice Sophia Akufo toured the whole country, and some courts were in deplorable state. She felt that no, it is not good. It is not conducive for staff. So she shut down some of those courts. That gave birth to these 122 courts we are talking about. Now, you go to some courts, even chair is a problem. The table that the judge will use is also a problem. So if we expect efficiency, effectiveness, and professionalism, I think we need to tackle these issues as well.
Right.
Because without doing that, it will not help us.
Right.
So if we will just turn on staff taking this, staff, they are doing this and that. In fact, the judiciary, we have staff, we have judges, we have lawyers. We have litigants who come to the court as well. So we cannot put everything on the staff, even though we are trying to eradicate all forms of those things in our midst. We also have to look at the issue holistically.
Right. So Yakubu Avote likes to focus on, if you like, machine, equipment, personnel. All right? And how much of the lack of that or the insufficiency of that, contributes to the delays and the other administrative, problems that lead to delays. But you will admit, won't you, that what the CJ spoke about, the issues that she isolated, are real.
Okay. Thank you very much, my elder, senior, and mentor. Before I delve into the matter, I want to especially congratulate you for the work that you did for us and what we've been doing. Because a lot of the challenges that we face and the perceptions formed about the courts centered on people's lack of understanding about how the work is done. It was for this reason that, as judicial service staff, we decided that you deserve to be honored as a champion of legal literacy with the law clinic program that you have today.
Thank you.
So first, we want to congratulate you on that. Now, coming back to what the Chief Justice had outlined as part of the challenges confronting the judiciary that borders on the staff, I wouldn't, because as a General Secretary, I sit in disciplinary committees sometimes with the permission of my boss to look at the issues. And what she said, truly, matters like that sometimes come for us to deal with.
Matters of conduct.
Yes, please, come for us to deal with.
And wrongful conduct.
Yes, please. And what she has said, some of you will find some of them. By then, if you have, let's say, hundreds of granules, and then you happen to have just one that is rotten among the 100, it is going to spell almost everything.
That's right.
So it is not up to the scale that people may be thinking that, as if it happens at every court. We have over 400 courts across the country, and the reports emanate from one or two or three courts across from the many courts that we are having. And it's also that something is not being done about it. People who have been found guilty of the misconduct are punished. There are also processes in place to train and retrain the staff through the paralegal training that the Chief Justice had organized. And we felt that it was a step in the right direction. That was why JUSAC had to give her the honor of a champion of staff welfare and advancement of judicial training or legal training for staff of the judicial service. So, and we believe that, I think we throughout the country, myself and then my president, in any region that we go to organize the staff to talk to them, the president will take his time to list a number of misconducts that has come before the Judicial Council,
such as,
and decision taken on
such
them.
as,
you may actually you will find issues of documents not being properly prepared, if like forgery, you may find
which the CJ speaks
which
about.
the CJ spoke about.
And then you talk about forging certain documents, court documents.
Sure.
Right.
So, and the issue goes beyond just the staff of the judicial service. There was an issue we encountered at Cape Coast Court where somebody was assisting a party to secure bail and obtain documents for the person. It was after the person took the money and ran away from the court, he was not being seen. And the litigants, the family of the accused, gathered the courage to approach the regional admin that they then started session. They gave the description, and when the person was discovered and arrested, it turned out that the person was neither a lawyer nor an employee of the judicial service. He just dressed nicely and then come to court, hover around the court. When he sees a wandering person who needs assistance, he pretends as if he's assistant. Maybe he will know one or two staff, or he may even know a judge. He goes to greet the judge as if he's doing something on behalf of the staff. These are some of the things that we are having. An effort is being made to ensure that we root out those, if like the Goro boys who come around the court to pretend to offer legal service to people, for which they do not have.
Of course, as far as the CJ is concerned, their days are numbered. People who put up such conduct.
Sure. And if you look at the administrative hurdles to justice delivery, I think that we can look at it from the perspective of before trial commences, during the trial, and then post-trial.
Help us to understand that.
Now, before trial, and it can also be categorized into the criminal cases as well as the civil cases. For instance, let me take criminal case because I had a little experience with it just within these days. When a court, an accused person, a suspect is arrested, he's at that point a subject of the police prosecution. But as soon as the person comes to court, the person becomes, and is admitted into bail, the person becomes a subject of the court. It becomes the duty of the court to ensure that the bail is being executed. But the police will have to also play a role at that point. You will find a great hurdle there. If the court says there should be sureties and give criteria or the qualification for those sureties, the courts cannot go and identify the sureties or bring the sureties when the accused person decides to jump bail. It is the police who will do that. So most of the time, you may find the accused person bringing his sureties to come and help him to execute his bail. And the police will say, we want to go and inspect the homes and properties that are going to be used as part of the bail process.
That's right.
And that is going to frustrate the accused person because his freedom is at stake. And it could even take up to 3 days during this period. The person, it should have been the court to do that. But if we also leave the police out of that equation and say we are the court, the person is our subject and we must deal with that, it's likely that if the accused person happens to abscond, we will want the police to go and they will ask us, we wanted to identify them properly and you did not give us a chance to do so because you felt it was what your subject.
Right.
So there are other actors in the justice delivery chain that brings about some of the hurdles that members of people will have to cross when they come to access justice. When it comes to matters during trial processes, sometimes parties come and they get frustrated with the processes. They come thinking that, oh, once I've come to court, I'm going to get justice done for me very, very quickly. And that is where lawyers also come in. A lawyer knows very well that maybe the case is not too good, and he will want to use the procedures provided in the law, not abuse it per se, but use it to his advantage to ensure that the case travels as long as it can, so that he can have, a way of serving his clients, serving the interests of his clients. We could have interlocutory applications that will come in the process that will have to be dealt with. And before the substantive matter is dealt with, the matter would have traveled for too long a period and parties get frustrated. When it comes to matters after a court has given a judgment, the judgment will have to be executed. It is the sheriff of the court who has to go and execute the judgment. When you ask senior counsel about the issue of how he has been satisfied with the case of the bailiffs, truly, the truth is that when a bailiff is to go and serve a process, you would have paid the money, including the cost of the service.
The service fee, yeah.
Which is 20 Ghana cedis. Okay. Now, the 20 Ghana cedis you are paying is not given to the bailiff. The registry don't spend. The money goes into an account. And after a month or a quarter, the bailiff now has to apply to the regional office to go and then what? Take the money from him. It means that at the point of filing the process, the bailiff has to use his money to go and what? Do the service. If he is prohibited or we told not to take money from anybody to do service, it means he has to use his personal money to go and what? Do the service. Then when the month ends or after a quarter, he goes to the regional office to receive the money. What if the bailiff doesn't have money of his own?
But that's the arrangement. As far as we know, we users of the court know that's the arrangement. So we come, we pay for the service fee, and all we are expecting is that the bailiff will go and serve our process. That's it. It shouldn't take them forever. And we know that when you are asking, has the service been done, the usual Ghanaian thing to do is, you have to direct service and direct it properly. Direct it properly means that there must be some
element.
Encouragement.
Assistance.
Assistance. The thing that you have already paid for, you still have to help the person with, the cost of transport.
So that's where the administrative changes will have to come in. We used to have impress given to the court. So that if the bailiff is going to serve, the registrar can give part of that money to the bailiff to go and do the service. Today, we don't have impress system. The registrar doesn't have money. If the bailiff doesn't have money, we are forced to find a way of getting the litigants to direct the service properly.
I'll come to Patrick now, but Mr. Afote, do I get the impression that on this issue of service and how the bailiffs get remunerated, you will suggest that there is some change in how, they are paid?
Yes, I think, like my brother said, sometimes a bailiff, for instance, how much is he being paid at all? You come to office and then maybe you have to do work. In fact, we are trying to find solution to these hurdles. So, like my brother just said, I am of the view that maybe an impress should be advanced. Because before the bailiff come to office, maybe he doesn't even have one city. And he have to travel, for a distance. And the lawyer or the party wanted the process to be served on time. So sometimes we need to look at this thing in a way. And when we do that, it will help the system.
All right. Listening to them, what do you have to say briefly about what they have to say before we come to you?
It's quite clear that the main issue here is some unnecessary bureaucracy and red tapeism that affects the work of the service. Admittedly, a lot of progress has been made in terms of infrastructure. I'll agree with what my brothers here were saying. A lot of progress has been made with the way things have done. Comparing, for instance, old cocoa affairs today to what the law court complex is. These are galaxies of the world apart. But it's evident that as we move along, we need to, in developing, tweak some of these issues or matters that bedevil the effective administration of justice and remove these hurdles. An example is, for instance, when you come to the issue of execution. We all know that for purpose of execution, we need police assistance, primarily for the preservation of law and order. Now, you have a situation where you've gotten your judgment, you've done everything at the registry, everything has been opened, wide docket, everything is done. Then the registrar has to write to the Ghana Police Service, that's headquarters. Headquarters will then write back to regional. Regional will then minute back to headquarters before it eventually comes to the registry. Now, if you have a successful party or plaintiff, or defendant for that matter, who has been successful, the inherent costs in getting the necessary assistance for police can sometimes be prohibitive. So, for instance, let's say your claim is 15,000 cedis. By the time you've gone the full gamut of getting police assistance, you spent maybe about 6,000 or 7,000 cedis. Now, what this happens is then this is prohibitive to people of lesser means. Why couldn't we have a system where, for instance, we have a specialized unit or detail of the Ghana Police Service attached to the registry of the court solely for the purposes of executions. So that, for instance, when the registrars have certified and are satisfied that all has been done, they then simply minute it to probably the next office where the police detail is. Because like I'm saying, we only need them really for the purpose of ensuring law and order. So I think that these are some of the things that we need to look at, where for purpose of execution, we can have a specialized unit that is attached to the registries of the court for purposes of aiding these things. So then it's probably a 24-hour matter, because the registrar is simply minuting to the next office, the commander of that police unit, where there are troops ready to move immediately. So these are some of the things that we can look at. But it's quite clear that, despite the immense progress that has been made and the fact that we are really getting somewhere, I mean, commendation to the Judicial Service and the Chief Justice, we need to tweak some of these bureaucratic matters that bedevil the system.
Right. And you wanted to look at, you're still here on the law, it's your legal light, it is your health law, and we are looking at administrative hurdles that, lead to delays in justice delivery. We will open the phone lines shortly, as we always do, so that you can join us and share with us what difficulties or challenges you may have encountered trying to use the court, and then it will help in a holistic outlook of what we are doing. My guests in the studio are Samuel Afotuotu, who is president of JUSAC, that's the Judicial Service Service Staff Association, and Abdullahi Yakubu is the general secretary of that association. Patrick Amati Sobajo is founding partner, Sobajo and Partners. He's a senior lawyer with a lot of years of experience and should help us appreciate these matters a lot better. You wanted to look beyond just the issues that the CJ lifted when she spoke, and spoke about their conduct of the staff, some of which are criminal, and she said them as it was.
Right.
What else should we be looking at? Who else in the system should we be looking at when we talk about the hurdles that cause the problems in justice delivery?
That's an easy one. I think the next set of people to look at will be my own colleagues, and in fact our colleagues and members of the bar,
right.
who sometimes, more often than not, are also part of the process. You have, for instance, the appellate system, where you're running an appeal, and you get to the stage where you're settling records. Right. Now, Order 11 of CI 19 and simultaneously CI 25 as well, the Court of Appeal rules and the Supreme Court rules respectfully tell us, how to include the necessary documents for appeal. What happens with us? We just stand up at the settlement of records stage and simply ask that everything be put in the record of appeal. Order 11 rule 1.2 actually states that the registrar shall exclude all irrelevant matters that are within the record. Now, certainly if we are appealing, the entire record of proceedings, all the witness statements, all the exhibits that have been tendered during trial cannot be relevant during appeal, certainly. But here we are, and our colleagues will go and we put everything in it. So by the time you're done, you have a voluminous record of appeal.
Yeah.
And these things are expensive. So again, if you are an appellant with limited means or a respondent with limited means, moving up ahead to the appeal process is difficult. Again, this is us. I mean, we should be able to distill what is relevant for the appeal and have the relevant records of proceedings with the specific evidence for which we are claiming we didn't get justice for.
Right.
And then be able to move on
That's the appeal process.
Yes.
But on the 50th anniversary, when Justice Osei spoke, actually took lawyers on.
Yes.
apart from the judicial service staff, which he also mentioned, had their own problems, and they, the judges themselves, the problems that they also had. He spoke about how lawyers can use the rules of court in a way to delay processes. So how are lawyers to blame in this process?
No, but
beyond the appeal process.
Coming down to the not appeal, original jurisdiction side. I mean, like you said, the court rules are there. They are there to aid the effective dispensation of justice. But what often happens is that at the end of the day, this is sacrificed by lawyers to become a competency or skill contest between us in terms of who's better on what the procedure is, and then leaving the substantive matter behind. Again, you find out that most often than not, it's the lawyer on, should I call it, the erring side, or on the side which, on the facts of the matter, his case doesn't look too good. And then you find that the processes are completely exploited in their favor. Again, if you take, for instance, commercial court procedure, pretrial protocols. The whole essence of pretrial was to enable us to be able to resolve the issues quickly and correctly. In the face of glaring evidence, we have our colleagues who will come and say, my lord or my lady, we can't settle the matter, let the matter be referred for trial. We're back in the mill again, joining the queue. Right. Meanwhile, on these issues, it is quite clear that this matter could have been resolved at pre-trial stage. So that is a clear example of situations where our colleagues or we members of the bar exploit the rules to simply elongate the whole process. Because I know that, look, if we don't resolve it at pre-trial, we have another 3-4 years down the line. Whereas if we resolve it at pre-trial, the matter is done.
So earlier you were mentioning about filing a writ together with an interlocutory process like an injunction.
Yes.
And it comes up often
that
one lawyer gets an injunction for their clients. After they get the injunction, they go to sleep. They don't want to facilitate the speedy process.
Yes, again, this is another issue, but it can easily be countered. I mean, if you are opposing counsel, again, the rules give us the necessary mechanisms with which to proceed and move along. I mean, you don't need to wait or depend on the plaintiff who issued the writ and or obtained the injunction. I mean, there are many mechanisms in the rules which lead us to that. I mean, today we are talking about processes and procedures, so I don't want us to get into substantive law. But again, it is a problem where counsel will go to sleep, commence an action, letters asking for all sorts of adjournments will come in, and then you meet your colleague downstairs. And then meanwhile, there's a letter upstairs in the case in which you just did, which he's supposed to be ill. So yes, the learned judge was right when he did take us on, because once you move from the issue of the staff of the judicial service, the next likely
Deputy Attorney General Alfred Choyebua says, the Attorney General Godfrey Dame has asked the CJ, sort of pleaded with the CJ to instruct judges who are handling galamsey matters, so to speak, mining-related issues, to ensure expeditious trials. And Alfred Choyebua says, it's all, it's a matter of the judge. If the judge wants the trial to be fast, they will get a fast trial. If they want things to end quickly, they can get it. So it is not about the lawyers and the parties, so to speak, even though they contribute somewhat. Where do you stand?
I will respectfully disagree with my learned brothers. In jurisprudence, what or who is a judge? The judge is the arbiter of fact and evidence. So the judge sits, and the parties bring their respective evidence for purposes of the judge to look at, weigh, and decide. If that information doesn't come to the judge, how does the judge expedite the trial? You understand my point? Are we assuming then that the judges have all that they have at their disposal, and for some reason they are refusing to process the case? I do not think so.
But we know judges who ensure a very fast process, where others have allowed things to slide?
Yeah, well, it depends on what is before the judge. I mean, if for instance, the prosecution come before the judge and they are not ready and willing to process the case and move along, of course, the judge should strike it out. You understand me? If you have a situation where it is the defendant's lawyer who is delaying the process, again, the practice directions and protocols allow the judge to move it along. So I don't think that we can simply say that we're pleading with judges to expedite the trial. It is those appearing before the judge, making sure that all the necessary information, be it witness statements, evidence, and so on and so forth, are before the judge. And of course, the judge will work. Let's not forget that these cases are also entering the system. Unless we are asking judges to pick which cases to process and move forward, then it's a totally different thing, because they are entering the mill, and the judge is sitting there with 300 cases already.
In the ordinary scheme of things, if we went to the High Court today in Accra, and your matter went to, say, Ifia Sare Boche's court, even though she's Justice of the Court of Appeal and still sitting in the High Court, you can guarantee that the case will not drag.
I will agree with you to a certain extent. We all know the learned justice as someone who pushes her cases fast, and in fact, many of her other colleagues also do. It's because
many or a few.
Well, I'll say many. It's because perhaps she's also eventually become known as a judge who will not allow you to waste the time in her court.
So it's in the power of a judge to determine that a matter is done speedily.
Yes, I agree. But you see, the judge will get to that point if all the necessary implements needed for her to make a decision are before her. You understand? That is a key factor.
If they insist on their timelines and they set them, they will get them because their colleagues are doing it and they are getting them.
Well, it doesn't happen like that in all cases.
Okay. The phone lines are activated now. You can join us with your questions, particularly if you are a user of the court and you know of some hurdles or frustrations that you may have encountered. Look at the screen. The phones you see, the phone line you see on the screen is what you should call us on. And be very snappy with your question, please. Thank you very much. Yes, Zavudi, you spoke about call them the bigger issues of tools and personnel, but you don't discount that staff have a role to ensure that justice is delivered smoothly and speedily. You don't discount that.
Well, actually, it is true. Staff, we have a very big role to play. And like I said earlier...
Without you, the system doesn't run.
Oh, yes. Yes. But this is something some people don't understand. I think sometimes treatment given to some of the staff from other offices and then maybe other court users is amazing. And some people think they can work without the staff. But sincerely speaking, all the fingers support each other. So the staff are doing their best. And even if maybe we are getting to the maybe better way or better side of doing things, we should also commend the staff as well as the judges, the lawyers, and others. When it's going bad too, we are part of it. And now we are doing more than what the CJ said. But
I'll come to you to tell me what you mean by difficulties that staff encounter, including dangers or perils that they are exposed to. Explain that to us properly. Kingsley, you're calling us from Taifa. Let's hear you. Hello, Kingsley. Manaf, Wakilu, let's hear you. Okay, I think we have a little problem. We'll sort it out and get back to you. Yes, hello? Yes, Manaf, let's hear you.
Respectfully, you sent a case call. In my, I was contacted by a candidate. I sent forward. There is covering hospital bills the second call.
Hello, Manaf.
Fine.
Hello, Manaf.
Yes.
State your case again. What are you saying? I didn't hear you from the beginning. What are you saying?
What I'm saying is that I sent a case to court. I was assaulted by a driver's mate. When I sent the case to court, I presented receipt covering the hospital bill. And then the bills were rejected, but the mate was fine. He was able to settle fine issues by the court, but in my case, I was never compensated. When I reported to the court that the fine against the mate.
Okay, so sometimes, like you said, the lack of education, the difficulty, you can tell that even Manaf has a difficulty in the communication to be direct about what he really, the situation is. But I'm discerning, if he says the person got a compensation, sort of, then that will be a civil matter. But he sounded at the beginning as if it's a criminal matter. Manaf, call back, and if you can try, gather your thoughts together so that you can speak directly and not equivocate as if you are not sure what you want to say. Kobe, let's hear you, Kobe.
Yes, Samson, greetings to you and your panelists.
Kobe, go ahead.
Great. My interest is with the bailiffs matter, directing service properly. Is there any way, maybe the judicial service staff there can tell us, is there a range or something, or is just arbitrary? The person can just tell you, pay this X amount, and sometimes because you are down there, you want your case to go, you just have to pay whatever the bailiff, you are at the mercy of the bailiff. That is my issue.
Well, what's the situation you have encountered?
Yeah, so my situation is, you call, you are directed to direct service, you go to a bailiff, and the bailiff is just asking you to
no,
pay.
I don't want.
He would ask you, where are we going?
Hello, Kobe.
Would say, let me drive you.
Hello, Kobe. Can you hear me? Hello, Kobe. You seem to sound like you're giving a hypothetical situation. I wanted you to be direct about it, if that is what you have encountered.
My position is,
okay, so Kobe has been listening to himself. You should listen to me directly on the phone and not on the television. But I suppose we get your point. So we'll look at it. Thank you very much. You can still call. We have some time to pick a couple of calls. If you have engaged with the court, if you're a court user or you ever did, what are some of the hurdles that you encountered administratively in making sure that you had a justice delivered to you? And let's see what we can do about that. So, Patrick,
yes.
Kobe's situation. Well, I think that question was to you.
You really asked me a question. Yeah.
Yes, so we will come to that, but let's get to Kobe.
Okay, so
yes, Yakubu.
So Kobe's question on the
a bailiff calls the party.
Okay.
Let's say is the plaintiff.
Okay.
And says you are supposed to direct service.
Okay.
He's asking if the bailiff has the power to dictate how much they are supposed to pay for it, or there's a fixed amount that they are supposed to pay to the bailiff.
Okay, so there is no amount that is to be paid to the bailiff. The fee is paid to the court, and it is 20 Ghana cedis.
Right.
That is the official fee. If the bailiff doesn't know the person you are litigating against, he can't go and serve the rate on any Samson, because there can be several Samsons in Ghana.
But you know that after the person has paid the service fee to the court,
yes,
when the bailiff is calling the person and saying, I need you to show me where the person lives so I can serve the process on them, sometimes, or we may say often, they will ask for assistance. And that's what he's talking about. That after they have paid the service fee, should they be paying some extra money to the bailiff?
Ideally, they should not be paying. But realistically, it will be very, very difficult. If the bailiff is to take, let's say, Uber, I took a Bolt to come to this place, and the distance from my house to here is not too far. I paid 45 Ghana cedis. The fee you are paying to the court is 20 Ghana cedis.
But that's not his problem. You have decided that you take 20 Ghana cedis.
That is what the system has put in place. So we will recommend that the service should consider, especially when they say it is under review, should consider upping the fee that is charged for bailiffs.
Right.
And also put in place the impress system so that when I'm going to serve, I will fill in a form and take the money to go and
Thank you. Justice, you are calling from Ablekuma. Hello, Justice. We just lost Justice. Okay, unfortunate. Do you have a comment about Kobe's question about dealing with the bailiffs?
Yeah, Samson, yes. I mean, that phone call that you referred to is literally a call to arms.
Yeah.
You must facilitate the bailiff. We are all painfully aware of the logistical problem. I mean, look, I don't know which distance in Accra today that 20 cities will get you. You know, so you can choose to, you know, be an ostrich and put your head in the sand and pay the 20 cities and hope that your process will get there. Or you could simply, as it were, facilitate the bailiff in getting there, be it picking him up yourself and driving him there, if it's possible, and or providing the necessary transport for him to go, which could be in the form of a vehicle itself, or
Will part of the problem be that these fees were fixed without, you know, taking account of potential inflation?
Of course. I mean, the system should have it in such a way that these fees are periodically reviewed, so that it makes it realistic for the process of the courts to be served. But if we're still looking at figures that were set, say, what, 3 or 4 or 5 years ago?
No, more than 3 years ago.
Well, there you go. You see, so the mechanism should be put in place where these figures are reviewed in line with transport hikes.
Right.
So if, you know, a GPRTC or whoever announces transport fares have gone up, automatically the fees should be reviewed.
I think that's the fairest point in that regard. Yes, Mr. Afote, so you were making the point.
Yes, please. In respect of...
So you were speaking when I took the call.
Yes. I think sometimes it is difficult on our part, I mean, especially the bailiffs again. And recently, a bailiff was brutally attacked by a fire service officer. And we have to intervene, and then we cite a person for contempt of court, and then 2 days sentence.
So you shared some pictures with me. Let's see 1 or 2 of those pictures of the assault that the bailiff suffered. But make the point about it.
That one has to do with the case in Amasaman.
Oh, that's different.
Court.
Okay.
Yes, court. That's second instance. And it's happening almost every day. It's becoming unbecoming. A bailiff was on his official duties to serve a party, I think around Ashalaja. Langas invaded on the bailiff. They brutally assaulted the bailiff. And in fact, it affected him mentally.
So this bailiff, that's the arm, and you can see he's being cut.
Yes. And it will surprise you that this particular bailiff is no more in the service. Whilst treating himself,
there's also a cut on his head, yeah.
He was given a vacation of post because he was unable to come to work. So the bailiff is no more in the service. So some of these things, in fact, it's really disturbing us.
Okay.
We don't have anything we call risk allowance for our people. They go, even recently, look at the attack in Tamale. They invaded the court, and they were even burning the court or whatever. We don't have anything called risk allowance.
All right.
Now the bailiff risked his life. He's no more in the service. And I was so surprised to have seen him out of the service. Nobody has even visited him in his house to see how he is faring, whether the litigants, the lawyers, the judges, in fact, the court itself is no more in it. They just dismiss him from his official duty.
Because he's not dismissed, because he's unable to come to work anymore.
Yes.
Okay. All right. Yes. What will be your final words about what you are doing to overcome the overwhelming impression that you are involved in a lot of rot in the system?
So first, I want to recommend to the public to utilize the court-connected ADR system because it helps to have speedy trial of cases. It's less expensive for you. Then also, I glanced through the 2009 Constitutional Review Committee reports, and one of the recommendations was about the independence of the judiciary, especially the financial independence of the judiciary. We have our internal generated funds that we reserve, and I think that it is time for us to reserve, if you like, the full amount of, or at least 80% of the revenues that we generate, so that we can use it to address some of the internal challenges.
You don't have to go chasing government and you don't get the money.
Definitely.
Okay. Let me come to Patrick. What will be your final words? What should be done to avoid these hurdles that have been identified?
I think that the various facets need to also communicate a bit more. Perhaps conference that includes judicial service staff, lawyers, and judges together, in a room to discuss and brainstorm on some of these things and look at making recommendations. It's quite clear that I'm saying that aside from the problems as Chief Justice highlighted, there are matters of bureaucracy, matters to do with lack of adequate funding, and also human resource issues, which were highlighted by this unfortunate bailiff who's no longer in the service.
Right.
But I think that if the three groups that make up the dispensation of justice in the country are concerned, we need to conference and dialogue to be able to deal with some of these issues, which are really procedural matters to enhance justice delivery in Ghana.
Thank you very much, Mr. Samuel Afote Otu, who is president of JUSAC, Abdullah Yakubu, a general secretary of JUSAC, and Patrick Amate Sobojo is founding partner, Sobojo and Partners. Thank you so very much. This has been The Law. It is your legal light. It is your help law. I'm Samson, Lardy, Anyenini. You wanted to say something in 30 seconds.
Yeah, my final words to our staff is to strictly abide by our code of conduct because it prohibited from so many things. And even to our staff, even though we all have our civic right, we are in election year. We should do it peacefully.
Okay.
And when we do that,
thank you.
everything will be okay.
Thank you very much.
Thank you.
Have a good afternoon.
Thank you, Samson.